opening the February 9th meeting of the Ad Hoc By-law Committee, which is, I had to formally do because we have a quorum in the room. Tonight we are here to discuss the many changes to Rutland's bylaws that the Ad Hoc By-law Committee intends to put forth at town meeting for approval. Very briefly, we'll do an introduction of the committee. We'll talk about the process that we're following. I'm sorry, camera, I know I move around a lot. We're going to give an overview for the changes that we're making, then we're going to do a deep review of all of chapters 1 and 2. Briefly, the committee, chaired by me, Peter Crane. Norm Anderson is our vice chair. Anita Clark is not only a registered voter, so she's eligible. Carlson, where did I say Clark from? I don't know. I apologize already.
No, clerk.
Didn't go very far before I started to make boo-boos, did I? She is not only a registered voter and eligible, she is our town clerk, and we have 2 at-large members, Ron Kent and Lynn Turcott. We have had 2 other members previously, Lindsay Demers and Karen Greenwood, who resigned from the committee at one point or another. We have a charge adopted by the Select Board to make a consistent format and presentation of the general bylaws, so we're not touching zoning, to modernize the content of the general bylaws based on, as it says, Mass General Law and what the courts have ruled, and also the way that Rutland actually does things. We are to prepare the body for approval at a future town meeting. At this town meeting, we will not be doing the entire body, but we're going to do the first 6 chapters, and to hold, just like this one, public information sessions about those changes so the public can be well informed before town meeting. Our overall process, the committee looks at the current bylaw and Mass General Law and court cases and other towns' bylaws and any other information we can get to propose a new bylaw. We send that bylaw to what we are calling a peer reviewer, and that peer reviewer is someone who has vested interest in the bylaw. Could be the police chief, it could be finance committee, it could be the town clerk, it could be the select board, and frequently is. And once that review is and that feedback cycle is complete, we send it to the select board for review. Why do we send it to the select board? Because nothing gets on the town meeting warrant without approval from the select board. And so we're giving them lots of things to think about well in advance, we hope, of town meeting so that we don't have a problem here. After that, the process varies a little bit. We will send it to town council, each bylaw, for legal review, and we hold a public information session, or we're doing what we're doing tonight. We're doing the public information session first, because not everything is locked down, and after it's locked down, we'll send it to legal review. And in either event, the end result is getting each bylaw to town meeting. What sort of changes are we putting in place? Very briefly, we are actually organizing the bylaws. We are going from this organically grown list of bylaws, which is just added in the sequence they're added, to an organization that groups related bylaws. We are going for a common formatting and font and verbiage and flow to make them easier for everyone to read. On top of that, we are dividing very long sentences and paragraphs. If you read the bylaws, there are lots of them that have one sentence 6 lines long that has 4 different thoughts in it. And we take each of those things and we break them down. So we're not only breaking them down, we're also trying to simplify the language without impacting the effect of the bylaw much of the time. What organization have we created? Well, we're going to propose 7 chapters. This lists them all. I don't want to read them to you, but this is the way that we've grouped them. And if you pay close attention to the way they're grouped, some things are could belong in a couple different chapters. For example, the Finance Committee bylaw, does that belong in financial affairs or does it belong in multi-member bodies? Well, at the end of the day, we said it's more important that they're lumped with the financial affairs side of the world rather than have to be lumped with the rest of the committees in town. Public and private ways and unmodified bylaws, which is everything we are not touching. In the future, unmodified bylaws will be divided into two chapters, one called Natural Resources and one called Other Matters. Other Matters is, of course, everything that doesn't fit in any other chapter, and we have enough of those too. Side-by-side comparison. Current town meetings bylaw, our proposed bylaw. Several things you may notice right away. We have a larger, hopefully more readable, certainly more readable for me, font. We have more white space in order to make things more visually distinct. We have a common flow. You will see every single bylaw. Section 1 is always purpose. Why does this bylaw exist? Section 2 is always authority. What gives the town the authority to write this bylaw? And then others, sections, when there are definitions that are specific to a bylaw, that will always be section 3. And beyond that is whatever needs to come in for the rest of the bylaw. Other things to point out, you'll notice we're putting together a complete book. We're not looking at this as a set of singular bylaws. And so by having a book, we can have nice titles that tell us where you are when you're scanning through or you're looking for a particular one. You can look at any page and see where you are. And as well as, by the way, page numbers that are constant or fluid throughout the book and monotonically increasing. So, there are really 3 kinds of changes. There are insubstantial changes that I don't talk about. Those are things that actually have no impact whatsoever. Those are things like fixing typographical errors. But if you're doing anything more to the bylaw than changing a typographical error, if you change a word, you change a piece of punctuation, you have made a substantive change to the bylaw. In fact, virtually all changes meet the definition that the AG uses for substantive bylaw changes. But there are changes, if all you look at is substantive changes between the old and the new, all you get is a mess of all the things that changed. And there are changes in formatting, and there are changes of wording, and changes of placement. We are using a new term called consequential changes. These are changes that change some attribute of the law in a way that is not just describing or expression of what you want it to do. These are things that change, as I said here, the intent or the effect of the bylaw. And the example that I use a lot is we are proposing changing the quorum at town meeting from 10 to 30 voters. That is not just substantive, that is consequential. We will be presenting a separate document for consequential changes to say, oh, what changed in town meeting? And we'll have a list of these things. Oh, what changed in general provisions? And we'll have a list of those things. Where do we find all these proposed amendments? Well, it's all on the Ad Hoc By-law Committee web page. Start at the town of Rutland, hover over boards and commissions, select Ad Hoc By-law Committee. That brings you to our homepage. And if you click over here and propose bylaw updates, you get, yes, the web page with all the proposed bylaw updates. This page covers everything that I've said in much more depth, but I'm even going to hit my time allotment for 15 minutes to get through this part of the introduction. So some things I want to point out on this web page, if I could. Come on. Thank you. Scrolling, organization, what we changed, all that. Our complete book, that's a hyperlink, will open a document that I'll show you in a minute. Remember that process chart? This table shows where every proposed bylaw is in that process. we went through so general provisions, the peer is the select board. All of these abbreviations are in the table just below this, define them. And on 31 January, we finished the select board review. And that also is the select board review for the next box, so that's all done at once. So it's about to go into legal review. Now, we haven't sent it off yet. We will soon. And look, the public information session is tonight, and our intent for everything on this list is 7 May. Well, the town meeting starts 7 May. There's also much down below this section. There's another section that has old and new revisions, not quite side by side the way I want, but at least you can get links to each one if you're interested in comparing them. Questions about any of that? Alrighty, then let's go to, come on. I'm looking sideways and backwards. So this is the latest publication of the entire body of bylaws. It consists of everything we're talking about changing and everything we're talking about not changing. It will all be published in this one book. Table of contents, nothing surprising there. You can see the bylaws to be updated, which are all the things we're not touching. Those will be for future town meetings. There's an introductory section that talks about the history of bylaws and describes how this publication is different from all the others. And here we are, general provisions. So chapter 1 is general provisions, and the first bylaw is general provisions. Let me pull up one of the document. Nope. Pull up the right place. Okay. We currently have a bylaw called General Provisions, so we are simply amending it. Again, we have a purpose. Provisions applicable to all town general bylaws. That will be important, especially as we get into definitions. And our authority is the General Laws, Chapter 40, Section 21, and Article 89 of the Massachusetts Constitution. Those two are going to be seen frequently. So we have a couple definitions that are going to, again, be important to understand how things work in the entire body of bylaws. One of those is that we have the word committee. By the way, when you see this arrow, that means we haven't finalized the text yet. That's my signal that the committee will work on that at its next meeting to finalize the language. So, a committee is any multi-member body of the town, whether it's a board, a committee, a commission, a council, a get-together. Whether permanent or ad hoc, appointed or elected. Doesn't matter how it's created, we're just going to call them committee. That way we don't have to say in many bylaws, the board or committee or commission, whatever, so it applies to all of them. Next one is a day, which is, for now at least, a calendar day excepting Sundays and holidays. So that we have a consistent definition of the word day throughout all the bylaws. Much of these are not terribly, town official turns out to be another one you see a lot, which is any town officer, employee, member of a committee, whether elected or appointed. So anybody who can talk, who can make a statement, acting as a member of the town and for at least a section of the town is a town official. What do I want to say? Section 4 is virtually the same as before. Section 5 is radically different. And the reason it's radically different, why aren't you going down? In fact, let me also zoom in a smidge. Make that a bit more readable for everybody. Okay. Section 5 is substantially rewritten. because what was in the original bylaw covered what was allowed for enforcement when that bylaw was written in 1941. Since then, the town adopted non-criminal disposition as an enforcement approach. And there is today a separate bylaw for that. It is our proposal that we do away with the separate non-criminal disposition bylaw and instead have as enforcement that we can enforce through any legal means, including non-criminal. Each day or instance that a violation exists or occurs shall constitute a separate offense. So if you do something more than once, you can be punished more than once. And by the way, oh, it doesn't say each day. We must have struck that. Somewhere, did I miss it? Oh yes, each day or instance. So something that that it violates constantly. Yes, ma'am.
So is that day defined by?
Well, this is one of those side effects that we need to talk about as a committee. Because there are some places where we need excluding Sundays and holidays, and this is one where I would maintain you're right that we don't want to exclude Sundays and holidays from that one.
Just one more thing about the definition of day. I wonder if there's a state of emergency and no business can be conducted via governor.
Mm-hmm.
I don't know if that is something that would be applicable to put into your definition of day. Just popped into my head.
I'm not sure. I actually think we're going to end up with two definitions of day, one for day, which is a calendar day, and one that's a working day, which is days excluding Sundays and holidays. Interestingly, there are side questions about how Saturdays fit into this. And although we don't count Saturdays as a working day, some places do. So we need to, again, this is something the bylaw committee needs to straighten.
So in our town, we could have committee meetings on Saturdays?
Yes. Absolutely, yes.
There is an MGL that we could accept, that a lot of towns have, that it's just.
That we
That makes that explicit.
We have not accepted that yet.
Correct.
Because I've always been told it's Monday through Friday that we can have committee meetings.
I think that's been more past practice than.
I'm with Anita. That's practice. That's not law.
But then that puts into, if we're having a committee meeting and asking for cable to staff that, is that now an overtime situation?
Exactly.
So,
Yep.
Yep.
That is an interesting question unto itself.
Well,
Look
because
how
I mean, if it is Saturdays, that frees up a lot of space.
It does. Fridays also open up a lot of space because nobody meets Fridays as near as I can tell. But what else do I want to say about that section? So I will say that the non-criminal disposition bylaw had two sections to it. One was the text of the law, and the other one was the fine table. The text that was important has been integrated into this section 5. The fine table is a whole different chapter in the book, a copy of which is available at the town clerk's office. And in fact, that's exactly what it says below. Schedule of offenses and fines. Here's a big, now this has both a substantive and a consequential change from the current bylaw. The current bylaw isn't legal. The current bylaw says, if otherwise specified, the penalty for each violation shall be up to $300, which is not legal. You have to give a specific dollar figure. And so we said $100 for anything that's not in the schedule of fines. And to be very clear, any police officer can enforce. There are a couple changes in section 6 and 7, which are how we name offices. It is our understanding from town council that with this wording, the office of Board of Selectmen, it is being replaced with the select board. And it is our understanding that is not offensive to MGL because many towns are doing things like this. There's an effort somewhere to do this in MGL, but that's a much longer term. If somebody really has the staying power to get through that, more power to them. This, section 7, is the exact same kind of thing for the treasurer collector, because by the special act of the legislature that created the office of, treasurer, town treasurer, I forget, the treasurer-town collector is the office according to the special act of the legislature. This supersedes that and makes treasurer collector an official title and an office. And finally, section 8, very, very, very important. And in fact, this one is really, really broad. So many bylaws today have a severability section saying if any section of this law is deemed invalid by a court of competent jurisdiction, that no other section is considered in violation of that. This takes that and says every single bylaw has that provision. Not only every bylaw, every regulation, and every rule that we create in the town, those all have severability clauses because of this. And that is the end of general provisions. Now, one of the things that I will point out before we move on is what's at the bottom of the last page of every bylaw is the bylaws history. So it's now easy to see when something was changed and what changed in it. It won't give word by word detail of what changed. As you can see, if we try to do that for this one, which is this edition, it's unworkable to try and get to list every single change. So it's added, removed, moved, and amended. I believe the 4 verbs that we use in the history section. So this went 4 years and change, 14 years, excuse me, before being amended. And then from 81 to 2017, which is 36 years if my math is right. And then we're trying to change it in 2022. Are there any questions about general provisions? I see no hands. Oh my gosh, no wonder that doesn't look right. I'm sorry, I had to change one other thing. Oh, there we go. As I said, we are proposing that non-criminal disposition be repealed. So the next bylaw is appointed committees. So again, boards, commissions, councils, whatever. But only the appointed ones. These rules have nothing to do with elected committees. Structure. We're doing this under Article 89, the Home Rule petition. So, let me just scroll a little more to show as much of this as I can at once. Every committee, unless otherwise specified, appointed by the select board, serve without pay, serve until such member vacates the seat, the term expires, or a successor is appointed. Any of those things can happen and the current member's out. Each committee elects its officers, and in fact, to a degree, each committee selects its officers, selects its offices. So there's always a chair, there's not always a vice chair. But there should always be a clerk who need not be a member of the committee, Anybody who's seen a select board, a Concom, a planning board sees Tamika in the background. She is the clerk for each of those committees, and the clerk is responsible to keep in timely file minutes, etc., etc. So committees can be appointed either every single year, like the 4th of July committee, or could be appointed to what are called staggered terms. And staggered terms is that you have a frequency of appointment, usually, but not always, 3 years. So every year, a third of the board gets reappointed. So all this says is that arrange the terms so that, as close as you can, 1/3 of the board gets appointed each year, or committee, excuse me. Expiring terms end at the conclusion of the fiscal year, that is to say, June 30th. 11:59 p.m. June 30. That's it, the term is over. A new term for any newly appointed member begins the next day, July 1. If someone vacates a seat, and we'll just use select board as our example, if somebody leaves Conservation and select board appoints a new member, that member's term ends when the original member's term would have ended. Here's a new thing taken from the Finance Committee bylaw. Select Board was really interested in this across the board. So, when any member is absent from 5 consecutive committee meetings, except in case of illness or other good cause, and upon majority vote of such committee, the member's seat shall be deemed vacant. You miss 5 in a row, the committee takes a vote, and if you're out, whether you resigned or not. Registered voters. Yes, this is what was put in some time ago now to start. This particular section has gone through a number of additions and an amendment since its original. I don't remember when it was first passed, but all this says is you've got to be a registered voter of the town. Wow, did that split weirdly?
Mhm.
I have to look at that. Can you take a note for that, please?
Yep.
Thank you. So, if you register to vote in another town, you're automatically out because you're not a registered voter of Rutland. Now, the one singular and fairly important exception is town employees may also be appointed to committees. Sometimes a town employee has special knowledge that is useful but does not live in Rutland. We've sat members of the assessor's office onto the solar committee as an example. This is what allows that to occur. And then, of course, if they don't have to be a registered voter, then moving doesn't impact their, doesn't create an automatic vacancy. I'm not going to go through this in great depth, but there is now a process for, again, I'm just going to say the select board, to remove members from a committee. My hypothetical, I use this a lot, and I get to use it because I'm on Concom. If we find someone from Concom is taking bribes, that's bad. And not only is that person in violation of the law and going to, one would hope, go to jail, that does not remove the person from the committee membership, from the committee seat. We need a way to remove somebody, and this is that process. I'm not going to go over it in depth. Everywhere where it says appointing authority is just whoever appoints that committee. Usually, but not exclusively, the select board. There's a hearing process and notification process, and authority in removing said member shall be final. That is to say, there's no recourse. If the appointing authority says you need to be removed, for whatever reason, you're removed, and there's no real recourse. I suppose there is a practical resource in going to court, But I don't need to mention that here, because that's not part of the town process. Questions on any of that? Man, we're flying through this tonight.
Excuse me, Peter, I have a question.
Yes, ma'am.
It's Michelle Van Reet.
Hi, Michelle.
Yeah. Hi. It's on the previous section that you were talking about members of committees, like appointed members of committees and their registered voter requirement. There you are.
Yes,
Yep. The registered voter requirement. We had a situation on the RDIC a few years ago where someone moved out of town, but the select board did allow them to stay on our committee for a period of time because that person had been on the committee since the inception. And I'm concerned that if there's no real, if this is kind of locked in that this is the bylaw and there's no provision in there, the person was not a town employee. So I saw where you said, you know, if they're a town employee, they could stay on there. But this person was not a town employee, but they had a depth and a wealth of knowledge that we could, it would have been detrimental to the committee had this person not been able to stay on it.
I understand what you're saying, Michelle. In fact, Cable Committee had a situation just like that, and the member was not allowed to stay. When we lost Addison, we completely lost his wealth of knowledge. The other thing I'd say is somebody moving out of town is not going to happen overnight, as a practical matter. And so if this person chooses not to tell the committees he's on that he's moving, doesn't give notice, I don't know what to say about that. But
well, the person gave notice. We knew that he was moving, but we were also, you know, in a lengthy process with the RFP, and I'm just concerned that this kind of ties the town's hands in saying that there's no provision in here that how could someone stay on for an amount of time. Well, the person didn't want to stay on forever, but it was very helpful for us to have the person there.
And the answer is the person can still attend meetings. If you hold public meetings, and if you were in executive session, the board committee can vote to allow a person into executive session. There is nothing that prevents any person from taking part in a meeting. The only thing it doesn't allow is that person to vote.
Got it. Yeah, and that would make sense. So that I wouldn't be opposed to that then. Yeah. Right. That's a good point. They could still attend the meetings. We could still allow them, as a committee, we could allow them to join our executive session.
That's exactly right. So there's a way for anybody who can help any committee to attend any meeting. Maybe even easier with Zoom, small plug. But there is nothing that would prevent, I don't know who you're talking about, but this person from attending a meeting and giving the information that the committee needs to make a thoughtful decision.
True. Okay, thank you. Yes, I hadn't really thought of it that way, but yes, you're right. Okay. And that answers my question then. That's fine. Thank you.
You're very welcome. Other questions about appointed committees? Now, a lot of this makes sense for elected committees as well, naming a chair. Setting up the elections of their elected regularly, only a third of the board gets lost at any election, but that's not bylaw. That's not within the scope of what we can regulate with the bylaw. All right, Chapter 2, General Government. This is all about the core of the government. It's not the entirety of the government. Yes, I have blank pages because I published a book. And a book, the first page of any chapter is always on the right-hand side. Yes, I have my hands in way too many things. Moving along. Town meetings. processing requirements for town meeting, and we have 2 sections of MGL that define what allow us to set the rules for town meeting. Okay, first, we took the longer paragraph and split it into 2 sections, one that says the election and other matters to be decided by ballot shall be held each year on the 2nd Monday of May. No change. The annual town meeting, wherein all business shall be considered except matters determined by ballot, shall be held each year on the Saturday following the 2nd Monday in May. Yes, ma'am.
So your previous slides, one of your first slides said you were codifying, you were doing all
Yeah.
these things. This is a substantive change that 5 people made a decision on, that the town meeting voted on to change it back to the previous Saturday so that we'd have everyone there. The government that made the decision for that town meeting would still be in place. The town meeting, Eddie Bracebridge.
To which I ask, to what end? Because the only change this can make is that no more than 2 members of the select board will be new. FinCom is still in place. Moderator, I lied, moderator would change. Could change. So the moderator could be new, and 2 members of the select board. In terms of the things that come up at town meeting, in the process of running town meeting, I don't want to say the town moderator is inconsequential. That is not. He is not. His function is very important, but somebody who understands how to run town meeting, anybody who understands how to run town meeting can.
A third of the planning board could change. And a lot of times there are bylaws that are on there that the planning board brings.
Now, planning is
Sometimes
just one person because it's a 5-year
Okay.
term.
But that's the whole thing. This to me is you're making a change that the voters said this is what we want.
You're right, but it's also after they voted to have it this way. This is the way it used to be.
I get it, but then during a town meeting, an annual town meeting, not a special town meeting, so it had the high rate of people showing up.
I get that.
It was voted to be so that too, if we ever had to do a Proposition 2.5 override for something to cover the budget, we would have the chance to explain that. Now we'd have the election, and as we see, these public information hearings are very well attended. So therefore, the town meeting is the best place to get it. I'm trying to figure out why it is that a 5-member board decided to change it when the town meeting, I think this should be a special warrant just for this piece because this is a major change. This is something that you guys have undone what the town has already voted.
Or if you prefer, redone what the town used to do. It's expressible both ways, Karen. So the fast answer is yes, the 5-member committee, and at the time I believe it was 7, when we made this change initially, said this is the right proposal. And it has been through select board review. And there was, I'm going to look to our select board member who happens to be in the room. I don't remember any, there was discussion, but there was no controversy about it.
I think if I can, I'll speak for myself.
Mm-hmm.
There's a lot of validity in what Karen says regarding a Proposition 2.5 override or something that would be discussed and settled, but then how does the vote work on, then it would be a subsequent Monday. I don't know which way makes the most sense.
Because I believe to do a special ballot is around $6,000-ish.
It could be,
Yeah.
that high.
So, I mean, in the case of a 2.5 override for the budget last year, when we thought, that we had to go in and we had to explain, we would have had to do that election twice. Potentially.
Potentially. Except for, like, the warrant for both the election and the town meeting, they're called on the same warrant. So it has to be planned ahead anyway, and a vote could be contingent on it. I think part of what this came out of is is the problem that our town meetings are early. The way it is, the way it got changed, forces our town meetings to be earlier in the year. And for a while, there was a call at annual town meetings to even push it out. And there was the question of, it always comes up, why is it always the weekend of Mother's Day weekend? So this change would, I think once in every quite a few years, it might still be Mother's Day weekend. But it also gives, I think, the town another week to prepare for the meeting after the election, after the warrant's gone out. But the other thing is, when that was voted, we didn't have a town administrator who tends to speak for,
On
to
many
speak.
matters.
Yeah. On that.
And I'll also point out something that Nina's not saying that impacts her. The amount of work to deal with an election in the town clerk's office is substantial, and the amount of work to deal with town meeting is substantial. And by putting them both within 2 days of each other, puts a tremendous load of work on the town clerk's office, and very little time to do all the work that's necessary, let alone anything more.
Yeah, there's no time to even start to wrap anything up, whereas the week before, it was really helpful. But
Except that we have very tight budget years, and we've had them. We've had to explain things and bring things forth to be brought to the ballot. And again, I'm going to keep saying it, but public information sessions are not well attended. The annual town meeting usually is pretty well attended. It's a good place to get the word out. And I'm afraid that what we're doing here by moving this is creating us to have to do 2 ballots on a year when we need a 2.5 override. And that puts us in a financial, we're not looking like it's going to be a breeze anytime soon. So that's putting, $6,000 in today's dollars for 2 elections. And I understand, the election has to stay the same because all 5 towns, I understand all that. But, so that's the push and shove, because those are the things that get and it's no different when we did the growth management bylaw. There's so many of those things that get put on the ballot that help to be there at the town meeting first, to help get the word out.
There is no singularly perfect answer, sounds cliche, but it's true. Because there are benefits to both ways. There are benefits of doing it one way, there's a benefit of doing it, there are benefits of doing it the other. I'm going to assert for a moment that this is the bylaw that's going to make it through the process and be put forth at town meeting. There is nothing that would stop any town meeting member from standing up and proposing an amendment to change the word following to the word before. And that would have the town vote explicitly on that thing. So as I say, I'm not saying there aren't benefits. I agree that there are benefits each way. And our own priorities will determine which makes it better overall. The committee has for all practical purposes voted.
But your charge was to codify, make fonts better, have them flow, not make changes, because this isn't how the town does it. The changes were to be when we weren't doing what the bylaw says. This isn't what the town does. This is a change.
And one could easily say that the charge is the minimum amount of work to be done by the committee, not the totality of work to be done by the committee.
Okay.
Peter, it's Michelle again.
Hi, Michelle.
Hi, I have a question too. Tagging along with I 100% agree with what Karen is saying. And I guess my question is, this has to go to the select board first before it would go on the town ballot anyway. So are you suggesting that we go to the select board meeting when this is proposed, so we could bring it up there to potentially get it changed at the select board meeting before we have to do an amendment on the floor?
The select board has already reviewed this bylaw.
And they agreed
They
with it?
reviewed it in a regular meeting a week ago, last Monday.
Okay,
And this was discussed.
okay.
So,
Maybe
and-
maybe this should have been brought up before they discussed it. Like, it would be helpful if we knew I guess it's either way, the cart before the horse, but anyway. So basically then, Karen, we would need to do an amendment on the floor?
Yep.
Is this already a done deal with the select board and we would need to do an amendment on the floor?
I cannot predict what the select board will do. There will come a time when the select board decides to place or not place the proposed warrant articles. But that's a warrant article placement, that's not review of an individual bylaw. So,
But what happens this year then? What is gonna be the format this year? Are we gonna do what we've always done, or are they gonna change it this year?
no, you can't change it until the bylaw is adopted and the Attorney General approves it. So, and that's 3 months later. So there's no change, no matter what's coming up in any of these proposed bylaws, none of this has force and effective law yet. None of it.
Got it, okay.
The current
Thank you.
bylaws are what we're doing everything by this year. And then, if the town adopts the bylaws, the amendments, then we go to the new bylaw revisions for next year.
Okay,
Humana,
Thank you.
small things, special town meeting in November and how that aligns with the AG's acceptance. There's a lot of hand waving here.
mm-hmm.
Other questions on this topic?
Well, this is how it was just done this past year.
Mm-mm.
No.
There was the elections.
No, we had.
That's true. This year, the elections were
Because-
pushed because the
because
elections
of
were held
COVID.
on date and town meeting had been pushed off substantially.
Okay. Because I remember that I was brand new, elected one
Right.
night. You know, so that's what it did.
And then we had to do a special election, all that kind of stuff, so.
Right, so in fact, the last 2 years,
Yeah.
we've had delayed town meeting with the election on that date.
Because of COVID.
And we expect no such provision this year to allow us to delay town meeting this year. Moving on, the committee believes, so MGL says that a town meeting must be held in the geographic limits of the town unless there's a bylaw that says otherwise. And so we wrote a section. Ordinarily, we're held within the limits of the town, but there can be conditions that allow us to change it to an adjacent or contiguous town. But no farther than that. We're not gonna have anybody drive to Worcester. But Holden or Barry High School, something, any of the adjacent towns we could move to. And again, has to be common assent of the moderator and a majority of the select board. So town moderator, if the select board says, yes, we want to move it, and town moderator says, no, it's not moving. Town moderator is not a single vote. He is a special office because of his duties for town meeting. Notice is the same as it was before, five public places, not less than 14 days. Quorum, I've already pointed this out, but I'll point it out again, raised from 10 to 30 registered voters.
And why did you think to change it to 30?
It was a neatest suggestion for the right number of people.
People have called for a long time that 10, that's, you know, the select board and the finance committee and the moderator and the town clerk were already, you know, over 10. So to increase that, and I went back and looked at the numbers over the last probably almost 20 years, and we were trying to find a safe number where it would ensure that we do have members of the public there, but we still wouldn't be in the position that so many other towns are now calling. So I feel confident that 30 is a safe number, that it gets boards there, but there will definitely be members of the public also. I mean, if it could probably change to 40, you know, but the only other one that did change, Peter, in the notice, we added the town's website.
Oh, that's true. I forgot about that. Thank you.
One word? Website?
Website's one word.
Website, one word?
Not in my dictionary, it's not.
Oh.
Web site, 2 words.
Okay, so Rutland's now going with the Peter Granger dictionary, not Webster's. Okay, so can we write a bylaw on that one too?
Don't even get me started on how bad Webster's is in the dictionary. They think.
I just want to make sure that the educational system gets that word out there, because I don't want any problems.
Moving on. We explicitly mentioned that we use town meeting time. Too many meetings I've heard, well, Robert's rule says we won't have to hear that. Well, I wish we wouldn't have to hear that anymore. I'll be honest, I know that it's still going to happen. Straight out of the last one, they're acted on in the order printed on the warrant. This is a small but truly consequential change. Every motion shall be presented in writing to the town clerk prior to the vote on such motion.
I thought it was after the vote occurred. Before the end of the meeting, you needed something in writing.
That wasn't in the bylaw, but that was
Common practice, but there was no bylaw. There's nothing in the bylaw that says when it needs to be presented. The reason that it's written this way is to force someone to get it in writing before the vote so that nobody forgets to do it.
And I have had to chase people, so.
Plus, it's read as it's presented and not possibly altered.
Mm-hmm.
Also gives town council a chance to review it.
Mm-hmm.
That's true.
Also could mean that we could be sitting there for a half an hour, 40 minutes while somebody writes up the motion, as we're trying to keep the meeting moving.
Well, if it takes that long to write the motion, how long was the motion?
Yeah.
Some of them have been quite long sometimes.
Some have been, I agree with that, but anyway. The next consequential change, we reduced the time from 10 minutes to 5.
And why was that?
And then they self-destruct.
10 minutes is a long time.
Oh, I know. Believe me, the person who sits in the front is always up there for 10 minutes on pretty much every motion, I know. But there are times when it does come in to bring about good things.
Unless such person's time shall be extended by vote of the body. There's always a hook to go longer. The town moderator gets to say, you're out of time. Mr. Moderator, I'd like to extend my time, please. Does the body concur? And a simple voice vote is enough for yeas and nays. We actually gave the moderator a new responsibility to a timekeeper for this. And we gave we have written a section that allows people who are not voting members of the body to speak. When Joe Buckley wants to speak, or Becky, they really need to be able to, so we wrote in a way to allow people to be recognized and to present. We wrote an explicit provision for secret ballots, which have been used while I've lived in Rutland.
But is it needed anymore now that we have the voting devices?
That's a funny thing. So it depends on how much you believe that the clickers are private. And the answer is uncomfortably, they're not really private. There is a way, we've never done, and we don't have plans to do, but there is a way to figure out every single person, how every single person voted on every single question.
But not after the fact.
Not right.
But it could be during the meeting, somebody could review.
Lots of things can happen. So, depending upon how privacy-centric someone wishes to make it, there is a way to do a truly secret ballot. This is one of those things where we still hope will never happen again. And hopefully, the clickers make people feel confident enough that they don't need to.
But a meeting member could call for a secret ballot, so we go prepared for that, just in
And
case.
the truth is, they're allowed to anyway.
And the only reason that, when people check in, we do number the slip, and that's mostly, those little clickers are pricey, and so we want to make sure we get them back. But after they're returned, and once the program is uploaded and the votes are all entered, we could never go back and see how somebody voted. It's just, somebody could, at that moment in time, like the moderator can see a number, but he doesn't know, although Randy says he knows what number he usually gets, so he can see if he votes. But it's very, I
mean,
would
there's
say,
only two people I know that see the numbers that vote, and it's usually assistant town clerk
right,
and the moderator.
right. 'Cause
And
I don't see
neither
that.
one of those people have the full list of who gets what.
Right. So it's 99.99% secret ballot.
Somebody
Feedbacking.
I think the feedback's
I'm muted. That's interesting.
Well, I think it just fixed itself. Moving on. So, as I said, we believe the provision will be rarely used, and even without this, the right exists, so this just sort of calls it to the forefront to say somebody can, and here's the process for doing it. Committee reports, nothing earth-shattering here. This is mostly rewording. But if your committee's created by town meeting, you've got to report the way that you said you would at town meeting. And the committee can be discharged just by not reporting it as it's supposed to. No action to dissolve the meeting. And by that we mean it's not just adjourn, it's the final adjournment, which has a different special Latin name, to dissolve the town meeting. Can't be done until every article's been considered and acted upon, and they can vote to postpone. This may be more important to us at this upcoming town meeting, because the committee has suggested to the select board that we have a two-part town meeting this year, where the first part is all the regular business and everything that happens there. And then we adjourn for 1 week. And then we hold the section of town meeting dealing with bylaws. I know that's actually going to happen, the decision hasn't been made, but if that happens, this is exactly the provision, even though this just codifies what we're allowed to do, so even though this isn't part of the current bylaw, at least not all of it is, there's no harm or foul there. And the not extend beyond midnight is a current provision. think,
That's it.
yep, that's it. Questions on town meeting?
I have a question, Peter. It's Michelle.
Yes, ma'am.
Why would we adjourn the meeting to the following week just for this? Why wouldn't we do it at the same meeting?
It depends on how long we expect everything to go. If we have, let me just pick a number. If we have 25 warrant articles of regular town business, and we have about 15 usually, just for all the budgetary, all the process, all of the, everything that goes on, if you look at all of those 15 warrant articles. And then we have, oh my gosh, 1 or 2 street acceptances, and a zoning bylaw change, and somebody has a citizen's petition for something. There's a lot that can make town meeting grow. This is one of the reasons the decision hasn't been made, but if the normal annual business is long enough, then I can see how town meeting would naturally go beyond midnight if they were including bylaws.
Right, but I guess why wouldn't it just take its natural course that if it does go up past midnight, you stop it at 11:59 or whatever? And haven't we voted to continue the meeting past midnight before, or past 11 o'clock before?
I don't remember a time that we've gone
I
beyond.
think I can remember one, yeah.
I
but
think
it's
I
been a
remember one
long
where we
time.
actually voted to continue because we were almost done. But I guess my point is that you've got the majority of people there that night, and to kind of plan that you're going to do this to adjourn it, I just think is not really right, because this is huge. This should be first on the warrant, or one of the first things on the warrant, and postpone other things.
The budget.
If this is potentially.
The budget.
No, Karen, obviously not the budget, but you know what I'm saying? Like I would postpone the streets or other smaller things like that. This is too big of a deal to postpone to another meeting when people, let's face it, aren't gonna go because it's only 1 or 2 items, right? So put some of the other things, but I think this needs to be done at the annual town meeting and not in a continuation. The select board needs to put this on early enough so that this does get debated by the majority of people that are going to show up, and that's going to be the night of the town meeting. Town meeting, not an adjourned one.
And I only believe that to be true if these articles are before the school budget. Because we've all seen the exodus after school budget. And you're left with, at the end of that meeting, the town hardys who will show up the following week to talk about bylaws. So, it is up to the select board.
People make plans, and I don't think that that's right at all. Because I always plan for town meeting, but I do make plans around town meeting, and I don't think it's right that something this huge would be postponed. That's just my opinion, and I can take it up with the select board too. But I think that this would be a mistake to postpone this article to another night.
At the end of the day, it is entirely the select board's decision.
Yep,
Entirely.
okay.
We've made a recommendation based upon town meeting behavior and length, but select board also asked, hey, if we say it's on the next week, but we find that we're ending early, can we pull it in? I don't know what the process to do that would be, but
Okay.
So and I don't disagree, Michelle, that these are very important things to be discussed at town meeting. I don't have an ideal answer that deals with the length of town meeting, and irrespective of the number of warrant articles to cover this, the potential discussions for these could easily be lengthy. And in truth, we're talking about putting 6 chapters of bylaws up, and you've seen 1 and a little bit of 1 chapter. We haven't even gotten the second article in chapter 2. So I would not be surprised by lively debate. If I believed the town would just say yay or nay, then I would not pause to say, let's just do it. But I don't believe for a moment with our town body that that's going to happen. I believe that there will be lively debate on certainly some of these issues. So how we leave enough time to do all the business of the town is a question that the select board is going to have to answer.
The other thing is, our committee did talk about doing this at a special town meeting, but what the consensus was that we should do it at an annual. But we were concerned, like Peter says, with how many articles would be on it. So that's when we started talking about the possibility of adjourn, only because at least that way, the people that come to the annual town meeting will get notice that that's what we're discussing. But
Yeah, I think the select board is gonna need to prioritize things though, because
I don't disagree. I also think that the prioritization, I don't think there's a singularly right prioritization either, in the same way that there's no singularly right sequence, there's no singularly right answer to a lot of these questions. So we do leave it up to the select board, because frankly, I hate to say it, Carol, good job. I think that's the end. Do we have anything else on town meeting? Yep, that's it for town meeting. Any other questions? Okay, select board. Above and beyond the title change and the obvious purpose and authority, we explicitly state that the select board, this is codifying in bylaw a number of decisions the town has made at town meeting. To go to 5 members, to be elected to a 3-year term, and explicitly stagger them. So this is one of those places, again, Karen, that we did extend beyond what the current bylaw says, but it clarifies the seats.
Yeah, but it didn't change it from 5 members to 7 members or from
True.
5 members to 3.
Yep.
I mean,
Oh, so the contents of most of this bylaw is new because we tried to, if you look in the current bylaws, you have to go through many bylaws to find all the things the select board is responsible for. So we collected those in this one bylaw. There are a couple of places where select board is still mentioned, and a couple of responsibilities that there's no place to put them other than in those other bylaws. But in general, this lays out the responsibilities. They are the CEO. Institute, prosecute, and defend any and all claims against or on behalf of the town, all of that. A small, I don't remember where we got this one from. This actually came out of the old legal affairs bylaw. And I don't remember if treasurer collector, that piece was in the current bylaw, or if we found that somewhere else. I don't remember anymore. And finally, there is a limit that the select board can elect to pay to settle any action. And that limit is $1,000. $1,001, you have to go to town meeting. The expectation, generally speaking, is that anything over $1,000 is likely to be settled by insurance. And that is not part of this because that's not the town making a payment. That's the insurance company making a payment. Select board shall have exclusive power to negotiate and enter into contracts. Yes, if it's a contract, it has to go through the select board. even though frequently negotiations for the contract are delegated to especially the town administrator, but not exclusively. So there are a few things here that, again, came from other bylaws. Select board shall place no article on any town meeting warrant accepting citizen petitions appropriating monies for a capital improvement until the capital improvement planning committee has considered such improvement. There was, it's not exactly these words, but it's a clause very much like that in the current CIPC bylaw. We moved it here to sort of make that responsibility front and center. Select board shall refer all articles in every town meeting warrant to the finance committee. Select board shall refer all proposed general bylaw changes to the bylaw committee. One would presume except those that the bylaw committee themselves propose. And select board shall act as the town's board of public works. Said board shall have all powers and duties defined in general laws, chapter 41, section 69D. This is another one of those codification and bylaw of what is in fact a town meeting vote and an election that voted to do this. 74, 73? I think one was in 73, the other was in 74.
The meeting in 73 and then the election in 74.
So, who does the select board appoint? This is a very different list than it is today. Town administrator, town council, town accountant, fire chief, treasurer collector, veterans agent, constables, members of non-elected committees. I'm going to leave 9 alone. So, every one of these appointments has a reference to the general law, that the Massachusetts general law that says this is a select board responsibility. Now, I know it will shock everyone in the room to discover that Mass general law has conflicts. Up until a few days ago, there was a section here about appointing the tree warden. Because MGL says tree warden shall be selected by the Board of Selectmen. Except that if you go to section 69D, the one that reference about the Board of Public Works, that one says the town warden is under the direction of the Board of Public Works, not under the direction of the Board of Selectmen. Finally, select board may appoint acting or interim for anybody they can appoint. This really has to do with town employees. It's unlikely to have anything to do with the appointed committee, but still. Suspension and removal authority, as long as they follow contracts, town policies, town bylaws, and the general laws. And this is one of those weird things about tax title, where some of the responsibility sits with the select board and some of it sits with the treasurer collector, and that's an MGL, and we have to say the select board shall be the tax title custodian for purposes of chapter 60, section 77B. Do I know what that is? Not anymore. It's been too long since I've read the darn law. And finally, in terms of appointment powers, they create, reorganize, consolidate, basically, select board can tear the town structure apart and put it back together any way they choose. That is a power of the CEO. Now, there's a whole section here that we're about to go, section 6, about, that basically says the town administrator is allowed to take part in all the meetings, except when they're discussing him for personnel action or contract discussions. And even then, there's a provision to allow the town administrator into those discussions. This explicitly says he's allowed to sit at that, it doesn't explicitly say he's allowed to sit at the table, but this is what lets him sit at the table at the front of the room with the select board and actively take part in the meeting. So you may notice back here, I know I pointed it out, Select Board has the authority to suspend or remove for just cause. Town administrator is always special. So we explicitly give a mechanism to suspend or remove the town administrator, separate from the other clause. This calls out a surprisingly long process, which I'm not going to bother going through right now. Please read it at your leisure on the webpage. As I said, the process goes on. And that's it for Select Board. Questions about the Select Board? Moving on. And now we come to the town administrator. I'm going to skip down here to DA to begin with to say, just like the Select Board is the Chief Executive Officer, the town administrator is the Chief Administrative Officer of the town. He's responsible for the day-to-day running of the town. Other than that, before contracted employee, and he's not allowed to hold other office in the town. So this, in fact, makes the town administrator ineligible to that. Employees can serve on an appointed committee. He's the exception. As you'll see later, he gets to take part in the meeting, but he cannot be a member of the committee. Which is almost splitting hairs. So, as I said, Chief Administrative Officer, responsible to the Select Board. He's responsible for implementing whatever the Select Board tells him to do. And generally, implicitly, by having enacted a policy, the Select Board has told him things to do. Chief Human Resources Officer, with all the duties of an HR officer. Town administrator shall be the appointing authority for all department heads subject to ratification of the Select Board within 2 weeks, which I believe is the gist of what we agreed to at the last meeting, but we'll bring it back next time. And the town administrator shall be the appointing authority for other officers, let's say anybody who is in the department head, subordinates, employees of the town, except employees of elected official and those who by statute or by law are appointed in some other way. Section 4 is another one of my least favorite sections because MGL, Chapter 143, Section 3O, says that there must be a bylaw to annually appoint an inspector of gas piping and gas appliances. How is that different from a building inspector or this person must report to the building inspector? So you would think that the building inspector would appoint him. No, has to be appointed by the town administrator. Can suspend or remove from cause anybody he has the power to appoint. Administrator may cause to be examined without notice the job-related affairs or conduct of any town department, officer, committee, or employee. By the way, the only change to this from the last time everybody else looked at it was I added committee. Regardless of the manner of selection of that department, officer, or employee. Doesn't matter how somebody's put into office. The TA can always examine that person's behavior and other habits that, that is like on-the-job behavior. This almost falls under HR, but we separated it for reasons. TA shall be the chief financial officer of the town, shall create the town's balanced annual operating and capital budgets, consult with the appropriate committees, recommend compensation for all town officers. This is one of those funny carryovers. In fact, this might have been a former select board power. I no longer remember. That may have been no, I don't remember anymore. But since he's got the budget, he gets to recommend the compensation, and the town administrator shall regularly and at least once per quarter review the town's expenditures for conformance with the budget. Again, I believe that's what we discussed at the last meeting. Chief Procurement Officer, Chief Information Officer, main point of contact for the media, and the main point of contact for intergovernmental affairs, whether it's state or federal or any quasi-governmental agency. TA is the point of contact for everybody. And finally, the town administrator shall supervise the administration of all appointed departments and committees. This is very similar to the Finance Committee's section on it. TA have access to all books and papers for anything necessary for proper performance of his job or her job. TA may be an active participant in any discussion during a meeting of an appointed committee, including discussions in executive session. He wants to show up to Concom? He's welcome to come and be a member. Planning board, not so much. That's an elected committee. This is actually fairly important. This power may not be designated to another individual or committee. Somewhere down below, there's something that says any of these powers can be delegated. This one can. It's got to be the TA himself, whether it's the TA proper or an acting/interim if you're in that situation. But he doesn't get to say, hey, Peter, go off on my behalf and go meet with the 4th of July committee about something they're doing. Can't do that. So, the town administrator shall coordinate the administration of grants, et cetera, et cetera, et cetera, et cetera. This does not say the town administrator accepts the grants. It does not say the town administrator is responsible for finding all the grants. Many grants are done by individual departments, and we're actually having a discussion with the select board about who formally approves a grant and which way should it actually work, based not only upon MGL, but also, once again, our current practices. TA can close the office during a snowstorm. Really, or COVID. TA can have the flag of the town flown at half staff. So that's only done by order of the TA. And as I said was coming up, TA may, unless otherwise prohibited, designate in writing an individual or committee to carry out any duty or responsibility. So if he wants to appoint a committee to help with the budget or to take care of creating a balanced budget, that's entirely within his purview. Is that really all? Isn't that enough? Yes, that's really all.
I have a question.
Yes, ma'am. Please, feel free.
It's Michelle again. Isn't that currently the select board
What's that?
that would designate these things? I don't think all of this is currently under the town administrator, is it? Isn't some of the stuff what the select board does?
No, as a rule, because it's not under the select board authority to do many of these things. Again, this is day-to-day running of the town that is supposed to be outside the purview of the select board now that we have a town administrator.
And this is an entirely new bylaw. that
That's
we
right.
don't have.
This is a brand new thing that we needed to harmonize our select board and our TA bylaws. So what
When
thing
you
you
talk
concerned
about
with?
the
Michelle?
appointment of department heads, would that be with the select board approval or not with select board approval?
Department heads explicitly have select board approval,
Okay.
as long as they do it within 2 weeks.
What do you mean as long as they do it within 2 weeks?
If they don't do it within 2 weeks, it's on. If the select board fails to meet and take action, then the appointment is a given, succeeds. So I can think of many cases where that's appropriate. The next time the chief of police comes up for his contract renewal, he needs to be reappointed. And there's no need for, other than contract agreement, but there's no need for, in terms of appointment, for the select board to actually take action on that. They can, because the select board has 2 weeks to do it. But if they choose not to take an action, if they choose not to meet for 2 weeks, then the appointment is a given. The appointment is considered ratified.
I think doesn't that grossly, not grossly, but doesn't that very much expand the town administrator's job description from what it currently is? That sounds more like a town manager than a town administrator. And I think we originally did a town administrator for this reason, that we didn't want to have someone have all of that power outside of the select board.
So the original wording did not have select board approval. We got that from some other town. We looked at 3 or 4 or 5 different towns' TA bylaw to come up with our mangled version that sort of, we hope, takes the best part of each. And at the last select board meeting, they pointed this exact thing out, and that's where we talked about, not the last select board, excuse me, it's not this past Monday, it's the Monday previous, where the selectmen and our bylaw committee met. And this is where we hashed out that if you need a department head, you don't want to wait forever for the select board to ratify. Because if you need a department head, you need a department head. And if the select board disapproves of what I will call proposed appointment, it behooves the select board to act quickly. Not just because you want to know it, you want that process followed through, but also so that the TA could start another search for the department head. There is a process to follow. Or there is usually a process. And so
the process has usually been, especially for a police chief or a fire chief or even the DPW, is that there's been a committee appointed by the select board of people to solicit and interview candidates and put forth a candidate. So is all of that being replaced with just the town administrator doing it?
Well,
Is that...
As a practical matter, most recently we have used search firms, and the town administrator has worked with the search firms to narrow down to create a list of eligible, valuable department heads. And that the result the result of that search, and perhaps another winnowing process beyond that to get down to a small number of candidates, the select board has tended to interview those candidates. And furthermore, this is where life gets again, there is no perfect expression of this, but most department heads are contracted employees. And who can sign a contract? The select board, and only the select board, unless they delegate. and I'm going to presume that the select board is not going to delegate contract signature to anybody else for a department head. Now, that's presumptuous on my part, I admit that. But it sure feels like that's the way it is.
And that's a big change from past practice. That's a big change from past practice, and I think that this isn't just codifying or formatting. These are major changes to what we've done in the past.
Since this whole bylaw is new, we tried to codify the way things are actually working. And I would submit to you that the only time the select board was directly involved in the dealing with the staffing agency was for the TA position. I would submit to you that the town administrator took care of the last fire chief, the last police chief. We're going to go to DPW for a second for lots of good reasons, but so I don't think this is in fact a big change. It has been changing over time, just sort of as the town has evolved to use a TA, the TA's taken on responsibilities. And this is the codification of that.
Right, but if this codifies and this is significant changes to the town administrator position, which sounds like more like a town manager than a town administrator, and it sounds like it's going to be a more costly position to the town. And I think the town made a very measured decision when we first did this we talked about having a town administrator versus a town manager, and this sounds like kind of backdooring to a town manager, and that's just how I'm seeing it right now, but I could be wrong. But
I understand that, but I will go back and say what I said before. These are not words we came up with on our own. These are words from other towns' town administrator bylaw. So it can't be that uncommon or we wouldn't have seen it, because we didn't do an exhaustive search, we did 5 or 6 towns.
But did you look at towns whose town administrators are in the same pay range as our town administrator? Or just look at town administrator, the title versus what they're, like, our town we can decide what we want in town administrator.
Yep.
And I think we did decide what we wanted in the town administrator. So going and looking at we looked at other towns and what other towns were doing at the time, right? So I'm not sure why we would make such changes.
As I say, I don't believe this is a significant change from our behaviors today. I don't believe you're correct.
I thought a town administrator was policy, not management.
But he is a manager. The town administrator is a manager of all the departments.
But I wonder if there's been scope creep from the first one, and I don't know. But I wonder if when this, like I said, I wasn't here for the first one. So, did it start out like that, and then as individuals came in, the scope of the job crept up to where now we are bordering maybe on to...
Right. So to directly answer one of your questions, Michelle, we did not consider pay rate when looking at the responsibilities of the town administrator. Didn't even consider it. It never entered my mind. I don't know that it ever entered anybody's mind on the committee.
I guess that's my point, though. It did enter our minds when we voted for the town administrator versus a town manager. It entered our minds that we did not want like what you would call like a strong town manager. We did not want one person responsible for running the town. We wanted it to be the town, like the town running the town. And if it meant, I get it that the select board has changed and kind of done their own thing recently, but in the past, we have had committees that have hired, and whether we use a consultant or not, I know the committees I was on when we did the police chief, I think we did the police chief and the DPW. I wasn't on the fire chief. But I don't believe that they used search firms necessarily, although they could have. But even if we did use a search firm, why not keep that? And I guess that would be a select board thing, but why, I don't know. But when we first voted for town administrator, it was for a town administrator, not a town manager. And I think this proposed bylaw changes a whole lot. And I just want to make sure people understand that. Because it's significant changes to what we voted for. And how much is it going to cost? Because the cost of paying somebody to do this stuff versus, what we could get from, whether it's the town, an appointed committee from town or whatever, or the select board doing it. And if people don't want to do it as being part of the select board, then they shouldn't run. But that was the select board's job for many years. And why not keep it with the select board?
It'd be interesting if anybody had the original scope of the job description.
Well, that's just it. I mean, I'll let you talk to what was presented at town meeting, but
It was really pretty basic, just allow the select board to appoint a town administrator. But you're right, some of it could have evolved over the years, but it hasn't been that many years either, so I think it would be good to probably take a look at Margaret's job description at the time and see if it changed between Margaret and Mike.
I think that's where it changed myself.
the copy I have is dated 2019, so that would have been modified since, oh no, I take it back, approved November 25, 2014. This is the TA job description.
So that
So-
would have been when Margaret came on.
That would have been Margaret's, and this is the one that Mike handed me as his job description. As I say, it may be a lively debate at town meeting.
I don't think the town administrator hired the fire chief. I think that was a committee and that was a select board.
Fire chief is by MGL a select board appointment.
Right. Because you had mentioned that the TA had hired it. I don't.
No, I'm saying the TA started the search job. I'm saying the TA hired the search committee. Not the search committee, the search firm that presented however many candidates to the town. And from there, I mean, the select board did interviews, and I don't know what,
We had Seth before Margaret started.
That's what I was just trying to look back in town reports to.
Seth was hired before
The
Margaret started.
timing was right around then.
Yeah,
I
so,
think.
as I was gonna say, we haven't had anybody yet
Right.
because of how everything's worked out. So that hasn't happened. The only,
I could be confused, but I would have sworn that
no, Seth was
that Seth
here.
came in.
Seth was here before Margaret started.
Right. And this is my point, is that there's a whole lot of significant changes in here that, these are significant. This isn't what we signed up for when we voted for the town administrator. And I think if we're going to change the job description that much, I think we need to really make sure that people understand that and agree to that, because I'll be honest, this is why it took so long to get the town administrator position approved in the first place, was because many of us were afraid of having one person having all of this control. And you still have to have that check and balance with the select board. And I think that the select board still needs to do the things that they've been doing historically. I don't know, I just think that this is a lot of change that yes, I think it is gonna maybe need a separate meeting, whether we call it a separate town meeting or a special town meeting or whatever we wanna call it. I'm not sure that a second town meeting in May is gonna be the appropriate way to do it, because May is a busy month anyway. People gripe about the town meeting being in May because that's when we're getting back outdoors and all the summer sports are starting up. I'm not sure exactly when the best time would be, maybe in the fall for the fall town meeting, but this is a huge thing to be doing. I'm just not sure about the timing.
Well, what I'll say is there are a number of proponents in town who say all bylaw amendments should be at annual and at no special town meeting. Now, I don't personally subscribe to that, but
I do subscribe to that, but you're telling me that you're already anticipating, like, adjourning the meeting to another date. And I'm saying that that's the problem, is that if you adjourn it to another date in May, you're potentially not going to have people there that would like to be there because of other things going on. It's a busy month. And I know we all make our priorities, but we also, that's why we would want to do it at the town meeting. That solidifies my point that this should be done, this should be a priority for the town meeting. The significant changes in here should be a priority for the annual town meeting and not an adjourned annual town meeting.
well, as I say, that is beyond my ability to control.
Start the town meeting.
Yes, thank you.
Well, that
Norm's
is the
idea
point.
started at noon.
We could, it's been done before.
Give us
We
12
could-
hours.
We could start it earlier.
And what, take a dinner break?
Yes.
I think we should serve cocktails and
Oh, hey,
It would make it more lively, but I don't know if it would make it more civil.
Ordering Chinese.
there you go. And everybody's sleepy. No, you can't do that.
bring in the food trucks.
Yeah.
Yeah.
All right, we got one more, and it's not very long. The Board of Public Works. This is actually an already existing bylaw. We just changed some things and clarified some things. But basically, the first two things say if it's a town property, the Board of Public Works is responsible for it, or a town building. Which, by the way, comes straight out of MGL.
Really?
Yes.
I thought the Board of Health was in charge of the landfill down off of Sharnak Hill.
Mm-hmm.
And I'm sure it can be delegated. Whether it has been, I don't know. But, again, the Board of Health at the end of the Board of Public Works at the end of the day has the responsibility by MGL and by our bylaw.
I would double check that. I know what you found in Mass General Law, but I would find out, because I'm the same in agreement, because Board of Health has had to come to us when we've had to restart, something had to be restarted because we let a year or two pass. I forget what that was.
Yes, again, I also agree that that can be delegated to the Board of Health with the sign of a pen. So I don't think, unless we can't find a delegation, which wouldn't be that hard to redo anyway if we really needed it.
Go back and take a look.
Yeah, we'll take a look. There's an arrow here, so we have stuff to look at here. The board, which is to say the Board of Public Works, shall appoint a superintendent of public works. Down below it says, this position shall from time to time be called Director of Public Works or some such similar title, because that's what Joe wants to be called. He doesn't want to be called what MGL says, the superintendent. He wants to be called the director. Fine. But the appointing authority is the Board of Public Works. It is not the Select Board, even though they're the same people. This is where it gets confusing. And the one that we moved from the Select Board, Board of Public Works, shall appoint a tree warden, who, suspiciously enough, happens to the same body of the person who's the superintendent of public works.
Where does this say that the Board of Public Works is a select board?
That was in the select board one that says the select board shall act as the Board of Public Works.
But, never mind. I'm beating a dead horse, and you don't care, so fine, whatever. It's just, when anyone reads this and they want to know who the Board of Public Works is, there's no way to say, well, you know, so now you're going in to see, and is the Board of Public Works listed on our town website?
I have no idea. Anita?
No, I don't
Right,
believe so.
so if somebody wanted to get in touch with the Board of Public Works,
Then
they
maybe it's
have
a
no
board.
idea who to go to.
That's a good point.
This is the same thing, you know, it's like, well, it says it here, but can we restate it here so that when someone's looking for this, you know, it's like when you wrote Chief Financial Officer. Well, is that Dan? Well, no, it's not. It says it here. Well, no one wants to read 306 pages of this to find out who they need to go to if there's a problem. If I need the tree warden, I want to know who I need to go to. And right now, this doesn't make it easy to find out who I need to go to.
Well, the tree warden, I mean, that's a separate problem. In
Yeah,
that,
but being that it falls under the Board of Public Works, you know, whatever.
I would completely agree that the website is lacking for this if there's no mention of Board of Public Works. There was even discussion at our joint meeting about this, that some members of the select board did not realize that there are two legally separable bodies with separate responsibilities.
So why wouldn't you just state it here? Again, just so that if someone needed to see this, that it says, you know, even a note at the bottom, refer to bylaw, blah, 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 page, blah, 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 for who sits somewhere, because right now, all that's gonna be is someone going up and going, who do I go to? How do I contact? It's not listed on the website. No one's gonna read 306 pages. If they wanna find a problem with the Board of Public Works, that should be easy enough to go here and find out who you need to go to.
Something between section 2 and section 3 that just
We
clarifies it.
we can put a footnote at the title.
Yeah.
Yeah, that's what I'm saying. It
Yeah.
just makes it
It's
easy
easy,
so that
yeah.
people know where to go.
Yeah, I'm not, yeah, I disagree, yep. Questions on the Board of Public Works?
That was separate a long time ago, same as
1973.
Yeah.
fencing and all that.
Well, actually, it's more complicated than that, because in '73, the town voted to accept the correct provisions of MGL, which created the Board of Public Works, which took the place of the Highway Department, the Sewer Commissioners, the Water Commissioners, Highway Department, the Tree Warden, and a few other, the cemeteries.
Yeah.
I forget what all the things are. There's a lot that's rolled in the Board of Public Works. And then in '78,
Well,
no, '83 is when the town voted to make the select board. No, I'm wrong
No,
about
in
that.
'74, when.
Yeah, right, '74 that they
But
voted.
'72 is when the vote was taken to form a Department of Public Works. So that's the one that put the highways and everything else into the DPW. And then it took a couple more years to do the Board of Public Works, but.
And actually, I was misremembering. It was the very next question. Question 1 is adopt the sections of MGL to create the Board of Public Works. And the very next question was to have the select board, the Board of Selectmen, act as the Board of Public Works.
Mhm.
Actually, I started to put something together for the select board, just for the dates and the meeting votes and things, just for reference.
That's it.
So believe it or not, that's the end of chapter 2.
And you want to do 6 chapters?
Yes. At the next one of these, sometime next month, we'll announce a date soon. We'll do chapters 3 and 4, which is financial affairs and it's 4 legal affairs.
I think so. I just left my spot here.
actually, I can look right here. I actually have it. Yes, financial affairs is 3 and legal affairs is 4. So more fun and frolicking awaits.
Correct.
But part of our thinking is, oh,
We have, Michelle, I see your hand is up. I apologize if that's been up for a long time and I missed it.
Sorry, it was up from before. I'll put it down.
Oh, okay. I've been looking at the wrong place for a hand this whole time. I apologize for that. Okay. Any questions on the first 2 chapters? Any more chapters? Information, debate?
But thank you. I'm glad I came.
Good.
Next public information session, could we get notice a little bit more than, I think, 48 hours?
Yes. Yep. I think
there was a lot of preparing to go into this one, so.
Hopefully we'll have notice, let's see, we'll agree on a date on Tuesday, and I'll put everything together the following weekend, so that, not this weekend, but the following weekend, we should be ready to post.
And what we've discussed doing is really encouraging people to go, because this is going to be available, to go read it, send in their comments so that we can discuss it at meetings. So, and just like a campaign to get more people aware of what's going on.
Well, I just think that just with these, what we saw here today, the changes from what was and what is needs to be in a separate document, because that change, there's some pretty major changes in these.
But if you,
So.
I get it,
yeah.
I get it. But what I'm saying is,
People.
just like the budget, there are those that will and those that won't.
No.
So we need to put it out there, so to make it easy for those to be able to come with questions. Otherwise, what happens is, it happens on the night of the meeting, and hours go by when they could have brought it and gotten it answered ahead of time.
So there will be another sentence right after this one that says, that'll describe consequential changes and say, you want to see the consequential changes? Click here.
Right.
And up will come a document that lists those consequential changes. Now, some of those elements that are truly consequential is the fact that we have a brand new town administrator bylaw. There's nothing to compare it against. So every change is consequential because it defines the town administrator. So that's not going to say something like, make the town administrator more like a town manager, because that's not the intent, and it's not.
No, but you could show the town the, you could go, this is the job description, and this is the bylaw. Granted, it's the first time we've had a bylaw for it, but you could show the job description.
Yeah.
And
If it's
then
online.
people who were there at the meeting and fought for
Yeah, I
a town
believe it is.
administrator can then look and see.
but we've had a town administrator for 8 years. That's why we were like saying, we have to get this to town meeting. We need a TA
I'm in
bylaw.
agreement, but it's just that the more information you put out there, the chances are that more people will take the time to do their homework ahead of time versus giving it to them when they walk through the door, and then we end up with discussions that take.
We completely concur that getting more information out sooner is better for all of us, and hopefully creates a shorter town meeting experience for the bylaws. We'll present what we can. Is the TA job description online?
I was
I don't
starting
know.
to
If so,
look. I think
you're
it
right,
is.
we can point to it. Where in the table today, it says, this is a brand new bylaw.
Right,
And instead we'll say, well, it's a brand new bylaw, but you can find the job description here.
right.
Mhm.
I don't think it is, but that doesn't mean.
Yep,
We can look that up.
yeah, it is there under TA. Let me make sure it's the one that, you said this, the one that we were working on was,
2014.
Right, it was from 2014, so.
there's, the one that's online is January 14th of 2019.
Ah, see, that's what this says down here, which makes me think that,
Yep.
And back here, it says approved in 2014, so. this
So
is-
it might be one and the same?
Yeah, I would not be surprised if it's the same. We can do a
'Cause-
compare.
'cause
Oh,
that
wait a
was all-
second.
that was-
Oh, that's the wrong place, that's Fairhaven. Oops. My mistake.
That was one of the towns we,
Yeah, that's all January 14, 2019. Yeah, my mistake.
So that was for current, Mike's, or
when Mike came.
He's only been here a year. Ron's only been here a year.
Yeah, it was October.
October was a year.
So almost a year and a half.
Yeah, but I think that's Mike's.
Yep, I think so too.
So I think we just want to double check if we can go back and find Margaret's.
That's what I think we should look at.
Go back to Margaret's,
It was a
because
good-
I think that's where, I agree with Michelle, we didn't want the town manager, we didn't want one, we wanted the overriding to be the elected official.
Okay. Other questions or comments? Getting darn close to 2 hours. Ah, 4 minutes to spare. Hearing nothing else. Is there any other business before the committee?
Motion to adjourn.
Second.
Thank you. And everybody's online, so, everybody's in the room, so all in favor?
Aye.